state and this honorable court.
Good morning. Our next case is State v. Lail, and we'll hear from the appellant.
May it please the court. I am Sherry Lawrence, a Special Deputy Attorney General with the North Carolina Department of Justice, and I represent the state in this case. I would like to reserve 5 minutes for rebuttal. This case is before the court on the state's notice of appeal based on Judge Tyson's dissenting opinion. The Court of Appeals majority erroneously determined that the trial court erred by excluding a note by Hazel that was written at some unknown time prior to her running away from home on April the 25th, 2020. The undated note describing a past and fictitious event was irrelevant, speculative, confusing, misleading, and prejudicial. The trial court did not abuse its discretion by excluding the note. At trial and during cross-examination, the defendant sought to introduce this undated note that Hazel identified as being in her handwriting. He attempted to introduce it as Defendant's Exhibit 1. The defendant argued that the note presented an alternate explanation that Hazel ran away from home to be with Larry rather than running away from home due to defendant's sexual abuse. The defendant did not seek to omit the note to show that Hazel made up fictional stories or fantasies, or that the allegations were one of her fictional stories or fantasies. The defendant did not establish a time frame for when the note was written, or that the note actually detailed events that truly occurred. Hazel admitted the note was written in her handwriting. However, she stated that she did not recall writing the note. She stated that the note could have been a fictitious story that she wrote about using names of people that she knew. As the proponent of the evidence, the defendant had to set out a valid basis for his admission. The defendant did not. As proffered, the note was irrelevant. Even if the note was relevant, the note was properly excluded under Rule 403. The record evidence shows that the trial court conducted a very thorough Rule 403 balancing test. The trial court exercised its discretion and applied the Rule 403 balancing test by conducting a voir dire on the evidence and hearing testimony. The trial court also heard arguments from both parties and determined that the evidence had no evidentiary value.
Didn't the trial court misstate the Rule 403 test? And don't we have a lot of case law that says that applying the wrong legal standard is an abuse of discretion?
Your Honor, the trial court did not include the word substantially when stating the Rule 403 balancing test. However, the trial court did state that there was no evidentiary value for this evidence at all. And this is the state's contention that the trial court properly balanced it, and by determining that there was no evidentiary value, the trial court in essence determined that the prejudicial effect substantially outweighed the probative value, because the ruling was that it had no evidentiary value at all.
Just so I understand your position, your reasoning is because the trial court said no evidentiary value, then necessarily the probative value was substantially outweighed by the danger of unfair prejudice.
That is correct. The trial court made a ruling, and it's the state's contention that the trial court did not utilize the word substantially in making that ruling determination that the prejudicial effect was outweighed the probative value. But the trial court in that same ruling also determined that it had no evidentiary value at all. And by doing so, it's our position that if the trial court determines that a piece of evidence has no evidentiary value, then the prejudicial effect of that evidence does substantially outweigh its probative value, because it has no evidentiary value at all. And I think what's most important here is the defendant's basis for asserting or seeking to admit the evidence, even to overcome Rule 401, before we even get to the balancing test.
So do you agree with the trial court that there was no evidentiary value to the note at all?
As presented. as the defendant presented the evidence, the trial court did make the correct ruling. The defendant here, and I know that the defendant makes additional arguments, and the Court of Appeals majority actually brought up additional arguments. However, looking at the transcript and how the defendant presented his argument, he presented it solely to show an alternate explanation for her running away from home. And looking at the note itself, it's on page 150 of the record. She stated, she is in quotation marks, is written in past tense, as to indicate, as the trial court indicated and the dissent both indicated, that would indicate is a past recordation of an event that had already occurred, and that the note, that she never returned to the home, even though the note was found in the home after April the 25th of 2020. So as proffered, no. It was the defendant as a proponent of the evidence to establish a basis for the admissibility of this evidence. The defendant argued in his brief to this court that it could show that she makes up stories, and this is one of those stories. However, that was not the argument before the trial court. The argument before the trial court was the alternate explanation. And the defendant, through his cross-examination, also sought to establish that, well, didn't you have to do dishes when you had the flu? That defendant was a bad man, and she saw him as a bad man, so therefore that's why she was running away from home. However, I think the defendant also has the issue of overcoming Rule 401, because even that evidence as proffered, what does it really show? It shows at some point in time, we don't know when because it's undated, the victim wrote this note prior to April 25th of 2020 about exiting the house to go with a boyfriend named Larry. So even if we assume that everything said in the note is true and that it had been admitted to the court to the jury, it would only show that she exited the room and she made this prior recordation. And the note actually mentions Jackie. The defendant didn't go into this at trial. However, the transcript shows at transcript page 83 that Jackie is her aunt, whom she did not reside with. And that would additionally support the fact that this is a fictitious note, and she admitted that she wrote stories about people that she knew. Because in the note it stated that Jackie, be quiet, we don't want to wake Jackie, Jackie's asleep. So I think that's additional corroboration to show that this was a fictitious note.
The defense counsel argued that it should be allowed for impeachment purposes, and the trial court seemed to say that, well, you can't use impeachment evidence unless that evidence is true. Is that right, that you can't use a prior statement as impeachment evidence unless the statement is true?
I think what's important is, I think what the trial court was getting at, the fact that how do you impeach someone with something when you cannot prove the veracity of the information in which you're impeaching them with? In this particular note, as written, as with quotation marks and in past tense, he could not establish anything with that. He did not articulate a basis for that either.
But can't you use impeachment, a prior statement as impeachment simply to show inconsistency without having to show that the one statement's true and the other statement's false?
I would agree with that. However, in this particular case, the inconsistencies were all before the jury. This was cumulative evidence.
What I'm getting at is,
Yes.
with this question and my prior question about the standard is, do we have a trial court that really sort of is misunderstanding what legal rules apply to this analysis?
I guess if you're asking me, I guess my opinion on that, do I believe that he misunderstood it? I would say no, based on the record. The record shows that he properly conducted the 403 analysis. It probably shows that he balanced it. And it was the misstate of that one magic word substantially in his analysis. Because I think also, going back to the defendant is the proponent of the evidence. So it's the defendant's job to bring the issue to the trial court. So I think that's why the trial court was having so many issues with this. And in fact, the trial court stated, I haven't got there yet. The defendant didn't provide that sufficient basis. I think the Court of Appeals majority in its opinion, stated that the evidence had probative value for two reasons: to show lack of credibility, and also two, to show an alternative perpetrator, which that gets into 412. However, no one wants to talk about 412. In fact, the Court of Appeals dropped a footnote in their opinion to state that this case is not about 412. However, their opinion is completely inconsistent by the mere fact that they stated that it can show an alternative perpetrator. So, how do you show an alternative perpetrator of the sexual abuse without getting into 412? In this particular case, there were physical findings. The nurse practitioner testified as to the physical findings to her that she had a transection in her hymen that went to the floor of her vagina internally. There was an opinion rendered by this nurse practitioner who opined that this was consistent with sexual abuse. So, this note, what other purpose did the defendant seek to admit this evidence? That's the purpose. The Court of Appeals stated it. However, the defendant attempted to circumvent 412 to get this under another basis, but could not sufficiently articulate that basis without getting around 412. Now, the Court of Appeals
Getting
majority...
back to the impeachment question, what, in your view, what was it that in the trial court's view, it thought was the purpose of the impeachment? What statements did HL make that were being impeached by this? Because the court seems to understand that that was one of the purposes of introducing it.
The basis in which the defendant presented it to show that she did not run away because of defendant's sexual abuse, but she ran away due to Larry, or going to see Larry. And that would be the purpose of the note, as the defendant proffered it.
But couldn't the court also understand just more broadly that it's her testimony that she doesn't run away? She'd never before run away.
That is correct.
And it would be relevant. It seems to me there is evidentiary value there. Because one way or the other, the jury would think about the fact that she had written this note, whether it was just something she's dreaming about or if she actually did it, and would seem to be relevant to the question of whether she was telling the truth now. So
Well, I don't think that's a fact of consequence that was at issue here, because the reason she ran away was of no consequence here. It wasn't the primary issue. And the Court of Appeals majority, I think, clearly stated that really wasn't the issue as to the reason why, even though that was the defendant's basis for his proffer. So I think that's the issue that's before this court, and that the issue that was before the trial court. The defendant did not make a sufficient proffer for the basis that he sought to admit the evidence.
So, as I understand the transcript and the defendant's proffer for impeachment, he's saying that he wants to introduce the note because she has testified that she never snuck out before. Not the reason, or even if the note's true, but she testified that she never snuck out before. And he wants to question her about this note because it could imply that she had snuck out before.
And I do understand your question, Your Honor. Again, that fact is of no consequence in this particular case. He established, meaning defendant's counsel cross-examined her thoroughly as to her reasons for sneaking out. He asked her multiple questions about, well, didn't you sneak out because your dad is mean? No. And he kind of continued along that line for pages of the transcript. So that was thoroughly before the jury. In addition, if it comes down to credibility, as the Court of Appeals majority points out, her credibility was not good. She was, I'm sorry.
No, sure.
The evidence showed that she was a liar, and that she lied 10 to 11 times during cross-examination, from pages 131 of the transcript, 134, 135, 136, 137, 138, 140, 146, and 147. 10 to 11 times she admitted to prior instances where she lied. So that evidence was cumulative, would have been cumulative. She was established as a liar. That was the evidence that the jury had, and that was the evidence that they had before them. And the trial court instructed them as to their duty to weigh the credibility. The defendant testified here. So we also have to remember that they had an opportunity to observe his credibility as well. And observing her credibility, his credibility, regardless of the fact that those 10 to 11 times, in addition, an officer of the law testified that she actually lied to him during initial report, an officer of the law. While she was trying to make a report of sexual abuse, she lied multiple times about her name, her date of birth, her age, the reason why she was where she was at the neighbor's house. She lied to Officer Priest multiple times, and that was before the jury. So I don't think there was any question that she was a liar. Her credibility was open, and it was very clear that she was not credible. However,
Does that go more to the question of prejudice than whether or not it was error to exclude questions about the note?
it definitely goes to prejudice, Your Honor, yes. Um, However, I think it also goes to the 403 analysis because it would be the needless presentation of cumulative evidence. Again, it would have been cumulative, and the question becomes what would it have added here versus the prejudicial effect of allowing the jury to infer that she had sex with Larry. And see, that's the elephant in the room here. That no one's mentioning sexual activity, no one's mentioning that she slept with Larry. Why? Why is that? The Court of Appeals let us know. They stated in their majority that it was for two purposes. One, lack of credibility, and two, as to an alternate perpetrator. And that was the real basis for this. The defendant did not present it as that because the state had filed a motion in limine to exclude this evidence. Could also be because the defendant did not make application under Rule 412 to get this evidence admitted. So the Court of Appeals majority pointed out that would be something for the state to raise. The state did raise it in a motion in limine. The defendant did not make application for it prior to trial, and the defendant did not meet the exceptions. So this is an attempt, and I think it's a clear attempt to backdoor Rule 412. Because for what other purpose did it show? The purpose that he stated, a reasonable explanation for why, an alternative explanation as to why she left home. Well, he cross-examined her thoroughly on that. Or this alternate perpetrator to explain those physical findings that a nurse opined was consistent with sexual abuse or sexual assault that could not have came from masturbation. So that was the reason. And considering all of the evidence, physical findings indicative of the heel hymenal injury that corroborated her testimony, there is not a reasonable possibility that the jury would have reached a different result. If there are no other questions, the state will reserve the remainder of its time for rebuttal.
Thank you, counsel. We'll hear from the appellate.
Good morning. May it please the court. Excuse me. I'm Candace Washington, and I'm an assistant appellate defender. I'm here representing the appellee, Mr. Lail. So this case was all about credibility. There was no physical evidence that identified Mr. Lail as the perpetrator of the alleged crimes, and Mr. Lail denied the allegations against him. HL's testimony was the only direct evidence on the ultimate issue at trial. This meant HL's credibility was particularly important, but the trial court prevented Mr. Lail from cross-examining her on a matter relevant to her credibility. The trial court effectively deprived Mr. Lail of his defense, and the Court of Appeals reached the correct decision by concluding that he was prejudiced by the trial court's abuse of discretion. This court should affirm the decision below. So I'm going to start with relevance. So first, trial counsel made a couple of different arguments regarding relevance, including, like Ms. Lawrence said, that the note went to explain an alternative reason for why she ran away, but he did also argue that it went to her believability as a witness. That's on page 156 of the transcript. And again, another argument that he made for relevance was that it could impeach her saying that she didn't run away before, right? So he made a couple different arguments for relevance.
I don't want to skip you ahead
Uh,
too much, but I do want to get to, because I have some questions about, I mean, I think you've done a good job of mapping out a series of statements by the trial court that seem to suggest the court was operating under several misapprehensions of the law.
mm,
And if we determine that, which would make even in a 403 ruling, that would be per se abuse of discretion,
mm,
then we're into prejudice. And it seems to me that this is where the state has a stronger argument. As I understand the state's argument is essentially that all this evidence was going to do was to damage her credibility,
mm.
HL's credibility, and it's already completely shot. You know, there's so many other examples of relying that there's just no reasonable possibility that one more example could impact the outcome. So it seems to me that's the heart of getting where you need to get in this case. So why is that wrong? Why is there? This is one of these harmless error cases where there is a reasonable possibility. So it was prejudicial.
Okay, so I'm happy to skip to prejudice. So one of the points is that the state is arguing that it's cumulative, right? So, and then State v. Williams didn't necessarily get into the whole cumulative explanation, but that is an explanation of why, when there's other credibility evidence in the record, that doesn't decrease the importance of the credibility evidence that was actually excluded. So like I said, the State v. Williams, and I think in that case, there was some credibility evidence, right, about the key witness's truthfulness. But this court harped on the fact that that was the key witness, right? So credibility was super important, especially when the defense's only defense is that that key witness isn't credible. So that was State v. Williams. And then the other fact that it's not cumulative is because this evidence that was excluded is kind of distinct from the other credibility evidence that we have in the record. So the other evidence regarding HL's credibility was about the fact that she lied, but she told lies about herself, or like little lies, like she admitted to lying, excuse me, about like not finishing her chores or finishing her homework, stuff like that. She lied about her age. But this line of cross-examination that was excluded, and that note showed that she lied and even made up stories about like the other people in her life, right? So that's distinct, and that's why this evidence that was excluded is not cumulative. And then even when we're talking about prejudice, it's preserved error here. So under 15A 1443, it's not a high burden, right? So this court in Reber, when it was explaining the difference between plain error, preserved error, it had a good quote that there can be a reasonable possibility of some event occurring even if it's not the most likely outcome. And I think that's what we have in this case. I already touched on the evidence that was excluded is not cumulative because it's distinct from other credibility evidence.
So let me go back to the prejudice aspect with regard to what could the defense attorney have argued if the note had been admitted? So what could the defense attorney have argued to the jury that the defense attorney didn't argue?
He would have just emphasized that she clearly makes up stories based on the people in her life, right? I think most of his closing argument was about the fact that, she told lies, and consider, she told that this story because she was mad that he canceled her sleepover. But the actual line of questioning and cross-examination would have driven his point home that she not only tells like little lies, she actually makes up these whole fictional stories based on the people in her life. And maybe these allegations are one of her made up stories.
So what would the note have, what arguments would have been made specifically from the note? I mean, that she lived with her aunt, that she didn't live with her aunt, that, your friend has argued that, well, the real purpose of this was to try to get another potential perpetrator for the physical injury before the jury. How do you respond to those?
So he never argued that it was to show an alternative perpetrator. And the note, like I said, it goes to the believability as a witness. So we have her on voir dire explaining the note, right? She said that sometimes she makes up stories based on the people in her life. This could have been a story or a dream. So that's what he would have been able to argue to the jury.
Could he have asked her, I'm sorry, I know I'm interrupting, but could he have asked her, do you make up stories?
You mean with or without the note?
Without the note. Just, isn't it true that you make up stories? And if she says no, you've got a different aspect or a different avenue to present the note. If she says yes, well, what kinds of stories? Couldn't the defense counsel have asked those questions?
I mean, he could have, but he didn't. So we're talking about the evidence that was excluded and why it should have been admitted. So if we had the note and her explanation on voir dire, it's that I make up stories. Sometimes I make up stories based on the people in my life. So he could have argued that part to the jury. And then the fact that it's fictional doesn't matter. This court, or not, excuse me, not this court, but the Court of Appeals has held that song lyrics, so essentially, art, whatever, works of fiction, can be used for non-hearsay purposes. So the fact that it's fictional doesn't matter. It still goes to her believability as a witness. And then just going back to the Rule 412 really quickly, the Court of Appeals made that offhand remark about it was being probative to another perpetrator, but the analysis wasn't based on that. That remark was like in the factual background, so that's dicta. But if you really look at the Court of Appeals opinion, it really focused on the whole credibility issue. And I'm gonna jump back.
Let me ask you, because to make sure I understand. So your argument is to get at the Chief Justice question. So what at closing argument, for example, is your position is the argument is you tell the jury, remember that note, and there was never a time when she snuck out and met her boyfriend, Larry. But this is a person who can make up such elaborate lies and even write them down with all these details. And so what happened here in this case, she did it again. She snuck out and got caught and was in a lot of trouble and made up another elaborate lie, this time saying that my client had done all sorts of things in order to get her out of trouble for sneaking out. That's what you're saying, that it would have provided some alternative reason to say, oh, she made the whole story up, everything about all of these crimes. That's your position?
Exactly. That would have added more.
And then you're saying there's a reasonable possibility, like you said, from Reaver. It doesn't have to be kind of a but-for thing, but there's a reasonable possibility that the jury would have heard that and said, we're kind of on the fence, and now we think not guilty. That's your position.
Exactly. And then it doesn't even have to be, I don't even think it has to be the whole jury to get like a completely not guilty verdict. If it's a different result, it could be a hung jury. That's really only one juror having that reasonable doubt about HL's credibility. So
let me throw something out there and get your take on it. It strikes me that, that a jury might be inclined to excuse the lies that the victim told to the law enforcement officer by saying, well, she's 13 and confronted with authority, and so it's understandable that she might be untruthful to begin with. But the note would be some evidence potentially of a lack of truthfulness apart from that scenario. And so the jury might be inclined to look at that and say, yeah, that does call her credibility into question in a way that the perhaps understandable lies to the officer would not. Is that?
I think that could be a part of it. But again, her lies to the police, whether it's because she was like scared of authority or not, her lies were like about herself. Like I said, she's lying about her age and why she left. And the note just adds a different layer. It's like, okay, she's not just lying about herself. She's lying about other people and making up, entirely different stories based on the people in her life. So I think that goes to that. And then of course the similarities and contradictions in the note kind of like tie it together too for why it's important to contest her credibility, because she's saying on direct examination she told the neighbors that she went to, she was 16, going to see a boyfriend, and then she's admitting on direct examination that she lied about her age and that she didn't actually have a boyfriend. And then we have her admitting on cross-examination that she was speaking to a man named Larry. And then this note kind of ties all of that together regarding her credibility, because on voir dire we see her saying, or we see the note refers to the man named Larry as her boyfriend, and she's explaining on voir dire that she thought he was her boyfriend, but he actually wasn't. She never met him, and we get back to the story thing. So it's all connected as far as we can see. Oh, she does make up stories based on the people in her life. So again, that still goes to the credibility aspect. And then I'm going to jump back to prejudice. So let's see if you have any more questions. But as I was just emphasizing earlier, the line of cross-examination and Defense Exhibit 1 that were excluded were distinct from the other credibility evidence in the record. And then in this case, like I said, it's really a credibility contest, right? We have physical evidence that she was sexually abused, right? But that physical evidence didn't necessarily implicate Mr. Lail. So we don't have any physical evidence that actually identifies Mr. Lail as the perpetrator. Of course, he denied the allegations against him. No other witnesses to say that Mr. Lail was acting untoward HL. So the only direct evidence we have is HL's testimony.
So let me ask you this. What precisely did the defendant argue as the reasons to admit the note?
So one of his first arguments was that it was an alternative explanation for why she ran away. And I think that starts...
So let's probe, or let's talk about that just a minute. That couldn't be an alternative explanation for why she ran away, could it? Because she had already run away. How did she get it back into the house?
I mean, that doesn't... If the note's still in the house, that just means she wrote it before she ran away. So she was just planning to run away. But as far as the relevancy, so that was one reason. He said alternative explanation for why she ran away. And then, of course, like I said, 156, he talks about its relevancy. It goes to her believability as a witness. And that's what my argument focused on. Because like I said, and like he argued, at one point she's testifying about having a boyfriend. Then this note refers to a man named Larry that she's calling her boyfriend. She said she was going to meet a boyfriend in Hickory. So it's kind of like the inconsistencies and the similarities in what she's saying isn't true, and then like what's actually happening in her real life. And of course, the other thing that he argued was impeachment, to impeach the fact that she said she never ran away before. But like I said, I focused on the one argument about her believability as a witness for those similar reasons. But and I hit on the cumulative. So I'm just gonna go ahead and wrap up and say that if the jury were able to assess this evidence, this important credibility evidence against HL, there's a reasonable possibility that the result of the trial would have been different. The jury might not have believed HL and found Mr. Lail not guilty. But as I said earlier, we don't even have to go that far because we're talking about reasonable possibility of a different result under 15A 1443. At minimum, at least one juror could have had a reasonable doubt that HL was telling the truth. That's a hung jury, and that's still a different outcome. So this case was all about credibility, but the jury wasn't allowed to fully assess HL's credibility. So we contend that Mr. Lail was prejudiced by the trial court's actions, and this court should affirm the Court of Appeals decision. Thank you.
Thank you, counsel. Rebuttal.
Your Honor. The victim in this case was a 13-year-old at the time. 13-year-old girl, that is. There was no basis established for this note. No sitting out where it came from, where they found it. Did they pull it out of a journal? Did they pull it out this 13-year-old girl's diary? But what we do know is what the note looked like. Page 150 of the record shows quotation marks around parts of the note. And as if she's telling a story, exactly what she testified to. Again, 13-year-old girl. No basis for where it came from. We don't know. She left the house on April the 25th, 2020, never returned.
So the way I understand the heart of your argument is that the proponent of this evidence, the defendant, didn't present it to the court in such a way that the court believed that it was, for whatever reason, necessary to be part of the case. I asked your friend, and let me ask you, could the defendant have asked whether she made up stories, and if those stories included people that she knew? And if she had said yes, that information would have come in. If she said no, then there would have been another opportunity, it appears, to have this admitted. Am I wrong in thinking that?
No, Your Honor, you are correct. Yes, the defense attorney could have asked that question. In fact, the defense attorney could have used that basis as an argument to seek to get this evidence admitted. We would contend that based on the transcript and the way that it looks, and as I stated, he was attempting to circumvent 412 and to get that evidence out there of showing the alternative perpetrator. So there was nothing to prohibit that, and I think the fact that he could have done that shows, it even strengthens the argument that this was an attempt to introduce Larry as an alternative perpetrator to explain the physical findings, because the credibility issue was already before the jury. She was a liar. She admitted she was a liar at trial. Officer said she lied, so that was definitely an issue, and this would have been cumulative evidence.
How would you characterize, I know you've done it before, but I want to be sure I get it. How would you characterize the reasons that the defendant wanted the admission of this note?
I would characterize that based on the way that he stated it on page 153 of the transcript, that I think the jury can consider that for further determination that she had a boyfriend, Larry, that she now says doesn't exist, and that she relied on him as a basis for her running away, and that she ran away to be with him as an alternative explanation for what she says the reason she ran away.
Would those be reasonable inferences from this note?
Based on, well, no, Your Honor. Based on how it was presented and the content of it, no, Your Honor. To show that alternative explanation, no. That would be our contention. And the basis in which he was seeking to use it without establishing all of those things I stated earlier, it would not accomplish that goal without more. And again, the defendant's counsel does argue today that they never argued at trial that the evidence could be used to show an alternative perpetrator. And as I stated, and I think I've belabored that point, of course not. They didn't because of Rule 412. That would have opened up a whole nother, argument or from the state, because the state had filed that motion in limine, and the defendant would have been required to, and was required to file application to get that evidence there. So this was the defendant's attempt to circumvent 412 to get evidence before the jury so they can infer, based on that note, that she had a boyfriend named Larry whom she snuck out to be with, and can infer a sexual relationship as to explain those physical findings.
But on page 158 of the transcript, defense counsel argues that the note is also relevant for impeachment purposes because she testified she had not snuck out before, and that, you know, entering the note into evidence would allow defense counsel to call that into question. So that's also a basis that the defense counsel argued.
Yes, Your Honor, that is a basis, and the defense counsel did explore that on cross-examination, and that was before the jury. So in light of all of the evidence, the evidence showed she was a liar. Even if the note had been admitted, it would have established what the jury already knew, that she lied and that she recorded at some prior time a fantasy or a story about sneaking out the window and leaving the house with Larry. The physical transection injury to HL's hymen, consistent with sexual abuse and blunt force trauma, would have still been before the jury. The physical evidence corroborated her testimony about the sexual abuse by showing physical damage to her internal vaginal area resulting from the defendant's sexual abuse. The trial court did not err or commit prejudicial error. Considering all the evidence, including the physical findings that the nurse practitioner testified to, that's indicative of a healed hymenal transection injury consistent with blunt force trauma, there is not a reasonable possibility that the jury would have reached a different verdict. If there are no further questions, the state will rest on its brief.
Thank you, counsel. Mr. Clark.